Right, so welcome everybody. It's a great pleasure to have Kevin join us. Kevin Toe is a man of deep mystery. If you try to track his origins, they disappear in the mists of time and journeys from one continent to another, from one country to another. But I'm glad he's found his way here. It's great to have him here. I've met him on a number of occasions elsewhere, and it's always a great pleasure to talk to him about all manner of things. And I think the paper he's presenting today is testimony to his rich imagination and his rigorous intellect. And I think it will spark a fairly further discussion, which I think is what you came here for, Kevin. But I'm looking forward to it, and thanks for joining us. Over to you.
Thank you very much, Andrew. Thank you for the introduction and for instigating the invitation. I'm very happy to be here. And thank you all for coming. What I'm presenting is a relatively early draft, but I wrote it about 8-9 months ago. And since then, I've done some more reading and thinking about these issues. So you should all have a handout. Some things in the handout are not in the paper, and there are some things in the paper that are not in the handout. I hope that's not necessarily a bad thing. But in any case, I hope what I present in the handout and in my talk is intelligible. Before we begin, I should mention also that you probably are noticing that my voice is not 100%. I'm at the tail end of a cold, and I've been tested for COVID, so you need not worry about that. It's taken a very long time for me to regain my voice, so I hope it doesn't interfere too much with the talk. In any case, in case that some things I say are unclear, I hope the handout will help. It's a long handout, so I hope that helps. So I want to begin by talking about two kinds of legal reasoning. I'm not saying that these are two only kinds, but at least there are two kinds of legal reasoning. The first kind we can call the rule-based reasoning, and this is the one that most of us find congenial and almost default form of legal reasoning. And here, example, if F, then do A, that could be a legal rule. That's the first premise. Second premise, F, statement of some fact. And the conclusion is do A. This is something that we all find quite natural to think in terms of. So according to this view, judge's job is to figure out which rule or rules that the facts of a new case fall under. Okay, so that's one type of reasoning. Here is another type of reasoning, which could be called example-based reasoning. So here, the facts of case C resemble in relevant ways the facts of cases D, E, and F. Therefore, C should be decided the way D, E, and F were decided. So here, instead of relying on rules, judges or lawyers would rely on examples, exemplars, paradigms, analogs, or some such. Now, in jurisprudence, I observed, though not in legal practice, example-driven reasoning has been overlooked or sidelined. And I suggest that some theoretical pathologies have resulted as a result of such oversight. Okay, so here is just one example in Chapter 7 of the Concept of Law, where H.L.A. Hart famously discusses legal reasoning or adjudication. Hart distinguishes early in the chapter that there are two ways in which laws can be conveyed, one by enactments, another by examples. But when he goes to explain what came to be known as hard cases, Hart explains hard cases in terms of indeterminacy of legal rules. And this last notion is explained in terms of vagueness or open texture of the predicates used to formulate legal rules. But if laws are conveyed by examples, there may not be a legal rule, or at least there may not be an authoritative formulation, linguistic formulation of a legal rule. So in effect, Hart seems to overlook the possibility of a case being easy, despite the fact that there is an indeterminacy of legal rules. So that's just one pathology. And I want to suggest that the overlooking or sliding of example-based reasoning has a long and distinguished history. And here I'm learning from Ian Hacking, some of Ian Hacking's last writings or last publications, and also a recent book by the historian Lorraine Daston on rules. Okay, Aristotle supposedly discussed example-driven reasoning, or what he called paradigmatic reasoning, in his work Rhetoric, before coming up with his theory of syllogistic reasoning in Posterior Analytics, which is a later work. Now, after the latter development, syllogistic or deductive reasoning, which guaranteed preservation of truth, became the gold standard of reasoning, and example-based reasoning was largely overlooked. And the rise of inductive logic after the probabilistic revolution around 1650 did not change the scene, as example-based reasoning is different from induction. So example-based reasoning continued to be used, especially in law, but it has long been a second-class citizen in terms of theoretical status. Okay. Now, I want to talk about legal reasoning mostly because I'm interested in legal facts. Okay. Now, by legal facts, what I mean is just considerations that make up what the law is. Okay. I do not mean to be adopting any particular metaphysical view. So I want to be neutral about the metaphysics of law in this talk. Now, a study of legal reasoning or interpretation or adjudication may reveal insights about legal facts, and that was Dworkin's strategy. So Dworkin famously argued that adjudication in hard cases showed that there are legal facts in addition to the rules that are validated by anything like what H.L.A. Hart called rules of recognition. Okay? And I will follow the same strategy pretty much. Okay, I will argue that how legal reasoning or adjudication works in lines of legal cases, lines of hard cases, shows something important about legal facts. Okay, so I want to provide a quick summary of the background for Dworkin's and my own claims about legal reasoning and its connection to legal facts. So Hart argued famously that when legal rules do not cover the facts of a new case, we have underdetermination by the law, and judges will then have to exercise discretion to decide a new case, which means that they have to decide based on extra legal considerations. It could be moral, it could be something else, policy considerations, right? But judges will still pretend to be fully constrained in their decision-making by rules, legal rules, okay? And legal realists sense things that are very similar. And that's not surprising because Hart's chapter 7 of Concept of Law was his reaction and his incorporation of what he took to be the insights of legal realists. Okay. So I'm on the second page of the handout now. According to legal realists, underdetermination by legal rules is a ubiquitous phenomenon. Judges' decisions are motivated by their moral views or policy preferences, not by legal rules. Yet, as Hart said, legal realists agree, judges pretend that their decisions are fully determined by legal rules. And these explanations in terms of legal rules are mere rationalizations according to legal realists. Now, I hope this sounds familiar to many of you, what legal realists say. Now, I'm going to rely heavily on Edward Levy's book, Introduction to Legal Reasoning in this talk. And Levy's book is often classified as a legal realist work. And there clearly are instances when Levy sounds like a legal realist. So at one point he says, reasoning by rules is just window dressing, he says. At the same time, I want to argue that Levy's book can be read as something quite different. Not legal realist, but something quite different from that. And the difference comes from Levy's emphasis on example-based reasoning. Okay, so in the second page of the handout, I have this table which lists all the cases that Levy discusses in section 2 of his book. And the cases deal with an exception that judges made to a common law rule, according to which the manufacturer's or seller's liability for any injuries arising from a negligently produced article was limited to the immediate buyer. Okay, so of course we're trying to figure out a way in which at least some third-party plaintiffs can recover for their injuries from the seller or the manufacturer of the articles. And Levy divides up these cases into 3 stages, and that's marked in those are marked in the table. In the first stage, the courts fumbled around for the right formulation of the exception to the rule that would allow some third parties to recover. And in the second stage, courts settled on the concept of inherently dangerous articles to be contrasted with articles that are only latently dangerous. Okay. But still, despite this new formulation of the exception, courts still relied on the similarities and differences between the cases to decide the cases. And depending on how they decided, they classified the relevant articles as inherently dangerous or only latently dangerous. And time to time, judges attempt to formulate a rule to bypass the need to decide the cases case by case, but none of the proposed rules took root. Okay, and finally, the third stage, the famous American common law judge Benjamin Cardozo, in deciding this case called McPherson v. New York, rejected the inherently dangerous category. It came up with a new rule. Okay, in terms of the category of things when negligently made are reasonably certain to cause injuries to those using them. Okay. So with this new rule, there was a significant legal change. But this is how Edward Levy diagnoses what happened as a result of the McPherson decision. He says that Cardozo's decision and rule do not enable judges to move past the need to rely on similarities and differences among the articles brought up by the new cases. Cardozo's ruling does not establish a general rule of negligence. So here is a direct quotation from Levy. Negligence itself must be given meaning by the examples to be included under it. Unlimited liability is not intended. As the comparison of cases proceeds, new categories will be stressed. The process of reasoning by example will decide. Now, this last passage, I think, should be read together with an earlier passage in Levy's book, which, if you read them first time, may appear puzzling. Okay, so the longer passage to come is at the top of page 3 of the handout. Okay, so Levy says, it cannot be said that the legal process is the application of known legal rules to diverse facts, yet it is a system of rules. The rules are discovered in the process of determining similarity and difference. If this is really reasoning done by common standards, thought of in terms of closed systems, it is imperfect unless some overall rule has announced that certain common ascertainable similarity is to be decisive, but no such fixed prior rule exists. Therefore, it appears that the kind of reasoning involved in the legal process is one in which the classification changes as the classification is made, the rules change until the rules are applied. More important, the rules arise out of a process which, while comparing fact situation, creates the rules and then applies them. Now, I hope I'm not the only one who finds this passage really, really puzzling. Okay, initially at least. But one thing is clear, I think. This is not a typical legal realist diagnosis of what goes on in the legal process. Okay. And my job is to try to come up with a new conception of what goes on in common law interpretation or adjudication to compete with the legal realist picture. Now, but let me compare the legal realist picture and the alternative picture that I'm about to construct. Here is one similarity. Both legal realism and the alternative view posits two levels at which the adjudicated reasoning takes place. One, the surface level, and the other, the underlying level. And both take the surface level to consist of rule-based reasoning, and both take the underlying level as what primarily drives the adjudicated process. Now, but there are some differences that I want to point to before I get into some of the details. There's a difference in how the two views conceive the underlying level. So legal realism takes the underlying level to consist of judges inferring conclusions from their moral views or policy preferences. And presumably, this is just more rule-based reasoning at the underlying level. Except that the rule is not the legal rule, but some moral rule or policy preference. The first premise, right? The alternative view I want to sketch takes the underlying level to consist of judges inferring conclusions from relations of similarity and differences among the cases. This is example-based reasoning. Okay. There is also a difference in how causally efficacious and sincere the surface level rule-based reasoning is taken to be. Legal realism takes the surface level to be largely epiphenomenal, mere rationalizations, window dressing, as Levy at one point says. Okay. The alternative view that I want to sketch takes the surface level to be reasoning based on rules that judges formulate in their attempts to approximate the underlying considerations. Okay, so there are at least two differences. Now, I want to go on to regiment the alternative view by relying on certain elements from the so-called connectionist program in cognitive science. Okay, now, so bear with me as I go through some of the details. Okay, now each case in Levy's line of tort cases could be represented as a multidimensional vector, with each component of the vector, meaning each number in a series that make up a vector, representing a magnitude along some particular dimension. Now, when we read the judicial opinions in Levy's line of cases, we see that judges are discussing a number of features of these cases, the fact situations. And here are some that I discerned in the opinions that did not make it into their inherently dangerous rule. Okay, whether the seller knew of the defect of the article, whether the defect was discoverable by due care inspection, whether the seller pointed out the defect to the buyer, whether the buyer tested the article, whether the seller committed fraud, how far down the chain of purchase the plaintiff was, whether the seller knew that someone in the plaintiff's position was likely to use the article, whether the seller was the manufacturer of the defective article or the defective part of the article, how much time after the time of purchase the plaintiff's injury was sustained, how far away from the point of purchase the plaintiff's injury was sustained, the extent of the plaintiff's injury. Now, as I said, these features did not figure in the inherently dangerous rule that judges were supposedly applying. Despite that, judges seem to treat these facts as significant in their decision making. So I'm thinking that each of these factors, or at least many of them, could be one of the components to make up a multi-place vector that represents a case or a case's fact situation. And each such n-dimensional vector representing a case could be mapped in an n-dimensional topological space of possibilities. Okay, and how similar or different the cases are with each other on multiple dimensions will be represented by how close or how far they are from each other in the topological space. And judges' job is to divide the cases into two sets. One set in which some third-party plaintiffs can recover, and the other set in which the third-party plaintiffs cannot recover. And we can think of judges working out a partition that divides the topological space into two subvolumes. And near the center of each subvolume would be the vectors that are prototypical of the set that go to that subvolume. So in the figure that's on the top of page 4, you have a figure that is supposed to make things easier to understand what I just described. Here, for ease of exposition, we have a cube that has only 3 dimensions, is a cube, right? But we can imagine, though we cannot picture a topological space with many, many more dimensions, say 11 dimensions, right? And we have a curved, shaded curved plane that's dividing up the topological space to 2 subvolumes. That's the partition that divides the 2 sets of cases. And within each subvolume, there is a spherical area that contains prototypical vectors for that subvolume, all the cases that were decided in one way, and all the cases that were decided the other way. Okay. Now, notice here that the prototypical vectors and also the partitions are creatures or statistical resultants of the vectors mapped in the relevant subvolume. And this means that the locations of the prototypical vectors and the partitions can change as the vectors for the new cases are mapped, added to the topological space. Okay, so with any new case, judges are to figure out whether the vector for the case is closer to one set of prototypical vectors or the other set of prototypical vectors. Or equivalently, the judge would be trying to figure out on which side of the partition the new case, the vector for the new case, should be mapped. Okay, so we get a model of what kinds of facts the judges would be discerning and reacting to when they decide cases based on relations of similarity and difference among the cases. Now, here's the question: how do judges develop the capacity to make such judgments of discrimination? How do they come to be attuned to such complex patterns of similarity and difference? And this is where the connectionist cognitive science really helps us, we think. Okay, so what connectionists do is that they liken human cognitive system to an artificial neural networks that consist of neural units that are connected by synapse-like connections. So I have just a figure, third figure, a handout in the middle of page 4 that has one kind of example of the kind of neural network that connectionists talk about. Okay, so on the left-hand side of that figure, we have 5 input units. There could be many more, but in this figure, we have only 5. And on the right-hand side, we have 2 output units. There could be many more output units, but for the examples that we're talking about, we have only 2 output units. So one of the output units would be for the cases in which third-party plaintiffs can recover. The other output unit would be cases in which third-party plaintiffs cannot recover. Or it could be something else. We could be talking about an email program that discriminates between real email and spam, right? Depending on the features of the input, it's able to discriminate in which folder the email should be placed. Okay. Now, how well a network does in issuing the right verdicts would depend on the weights of the connections between the units, or the thickness of the connections, so to speak. Some connections are excitatory, meaning that they have positive weights, whereas some connections are inhibitory, meaning that they have negative weights. And weights of the connections determine how much some detective feature should be weighed in issuing one output verdict or the other. Okay, and the most interesting thing about connectionist program is that these weights need not be set by the computer scientists one by one. Instead, the networks can be trained to tune the weights themselves. Okay, so a network undergoes training by being exposed to a training regimen or data set. During training, whenever the network issues a wrong verdict, a discrepancy-reducing learning rule tweaks the weights of the connections that are most responsible for the wrong verdict. So in the course of training over time, under the pressure of such repeated error corrections, the network undergoes the process of what computer scientists call gradient descent. It inches its way down an error gradient towards a global minimum. And the final figure I have on the handout, which is at the top of page 5, illustrates gradient descent. Here, notice that the y-axis is the percentage of errors, and we have only 2 dimensions that are depicted in the cube. But once again, we can imagine many, many more dimensions. Okay? So in effect, a network can be trained to develop certain discriminatory powers, ability to discriminate among different kinds of patterns in the input data. And my speculation is that legal education and experience on the bench enable judges to achieve analogous gradient descents. They develop certain discriminatory powers under the pressures of repeated error corrections provided by the court system. That's the hypothesis that I'm playing with. Now, we now have some idea of how judges could come to acquire access to the underlying legal facts that consist of relations of similarity and difference among cases, which can be represented by prototypical vectors and partitions. Now, here is a question that I want to raise. What is the relation between the example-based reasoning at the underlying level and the rule-based reasoning at the surface level? Okay, why isn't it that we just go by one or the other? Why do we do both? Okay. Now, what leading discussion suggests is that we should think of legal rules as imperfect and at best temporally adequate approximations of the underlying relations of similarity and differences among the cases. Now, if judges had knowledge of such underlying facts of similarity and difference, then they would have representations of such facts in their cognitive systems. And these representations would be motivating them when they decide cases. Yet, I want to suggest they're likely to suffer from certain epistemic limitations. And this explains, I think, why we have these 2 levels. Okay? There's what I will call inscrutability. So even if judges had such representations, they may have only imperfect access to such representations, right? Some influential psychological studies suggest that people in general are unaware of the considerations that actually influence their judgments and choices. Okay. Now, this is explained in part by the multidimensionality of the patterns of the patterns in similarity and difference among the cases, which would mean that judges would have a difficult time grasping them clearly. And if you look back at the second to last figure, we didn't discuss the hidden units that come between the input units and the output units. The fact that there are hidden units suggests that what judges would be dealing with are units that discern patterns in the input patterns. Okay, so the these hidden units would represent higher order patterns that would be especially difficult for judges to grasp. Okay, now in addition to this factor of inscrutability, there is also inexpressibility. So even if judges had ready access to the relevant representations, the multidimensionality of the patterns and the higher order nature of the patterns would mean that judges are likely to lack the vocabulary, fine-grained vocabulary in any public language to articulate the representations. And then there is the modifiability. What legal rules can approximate are in effect the locations of the prototypical vectors and the partitions in the relevant topological space. And these are creatures of all the vectors in the subvolumes and will change as new cases are mapped in the topological space. The bottom line is that in many cases, our ability to discriminate between certain properties would exceed our ability to see and articulate the basis of such discriminations. Now, as a result of this connectionist suggestions or resources, I think we can make good sense of what Levy said in that puzzling passage that I read earlier. Once again, he says, it cannot be said that the legal process is the application of known legal rules to diverse facts, yet it is a system of rules. The rules are discovered in the process of determining similarity and difference. Therefore, it appears that the kind of reasoning involved in the legal process is one in which the classification changes as the classification is made. The rules change as the rules are applied. More important, the rules arise out of a process which, while comparing fact situation, creates the rules and then applies them. And I think that makes perfect sense in line of the connectionist resources that I've been sketching. Additionally, I think we can make good sense of what Oliver Wendell Holmes Jr., perhaps the most celebrated judge in American legal history, excuse me, has said in a number of places. The first quotation comes from his very famous dissenting opinion in the 1905 case, Lochner v. New York. Holmes says, general propositions do not decide concrete cases. The decision will depend on a judgment or intuition more subtle than any articulate major premise. That makes perfect sense in light of what connectionists provide. And Holmes also says, the growth of law is very apt to take place in this way. Two widely different cases suggest a general distinction, which is a clear one when stated broadly, but as new cases cluster around the opposite poles and begin to approach each other, the distinction becomes more difficult to trace. The determinations are made one way or the other on a very slight preponderance of feeling rather than articulate reason, and at last a mathematical line is arrived at by the content of contrary decisions. The inscrutability and the inexpressibility of the representations of the underlying facts of similarity and difference explain the unavailability of the general propositions, major premises, as Holmes calls them. And the mathematical line that Holmes is talking about is the partition between the two subvolumes in the topological space. And Holmes's talk of intuitions and preponderance of feeling makes sense given that the attunement of judges' discriminatory powers, their gradient descent, is likely achieved and maintained by our affective system, our emotions. Okay. Now, even if legal rules tend to be inaccurate approximations that are only temporarily serviceable, they are not mere rationalizations according to this alternative view that I've been sketching with the help of connectionists. They're at best like good rules of thumb that enable judges and others to gain some limited, if imperfect, access to the underlying legal facts and to enable them to instigate coordination with each other. And what judges and others need to clearly recognize is what Lorraine Daston calls the thickness of legal rules. Okay, according to Daston, thin rules are those that formulations of the rules alone can enable people to follow the rules correctly, whereas thick rules are those that people need to study some examples and exceptions of in order to figure out how to follow correctly. I think Levy's point is that legal rules, or at least in many cases of legal rules, are thick rules in Daston's sense. Okay, now let me finally turn to the topic of legal facts. I've been talking a lot about legal reasoning and how this has implications about legal facts. And let me review the background to talking about legal facts here, slightly different way than I did at the beginning of my talk. So in characterizing Dworkin's view, H.L.A. Hart used the terms explicit law and implicit law. By explicit law, what he had in mind are the rules that are validated by something like the community's rule of recognition. And according to Dworkin, in addition to such explicit law, there is the implicit law of a community, which consists of the moral principles that justify the explicit law. And Dworkin relied on his study of adjudication in hard cases to argue for the existence of implicit law. But his particular conception of implicit law, I think, is problematic. because it appears to exclude the possibility of morally unjustifiable legal systems. Now, by studying how legal reasoning works in lines of common law cases, like the ones that Levy discusses, I think we can devise a different conception of implicit law. The implicit law consists of the patterns of similarity and differences among the cases in such lines of cases. We can also think of the implicit law as consisting of the locations of the prototypical vectors and the partitions. Now, Levy, what I've discussed so far are what Levy discusses in section 2 of his book, where he discusses common law interpretation. But in section 3 and 4 of his book, Levy goes on to argue that kind of example-based reasoning that he discussed earlier is also characteristic of statutory and constitutional interpretation. So if Levy is right about what he discussed in section 2 of his book, then his conclusions about implicit law seems to apply across the legal board, it appears. Now, we may also reconsider the notion of discretion, which was the initial bone of contention between Dworkin and Hart, and which has been a very important consideration in thinking about the nature of law in 20th century thinking about the nature of law. In talking about discretion, Hart in chapter 7 of the concept of law, once again, was talking about judges making decisions when legal facts underdetermine outcomes, and they need to rely on extra legal considerations. And Dworkin initially criticized Hart by arguing that judges exercise discretion, or Dworkin argued that judges never exercise discretion in that sense. Now, what Daston observes in the recent book is that discretion has traditionally meant adapting a rule for the particular characteristics of a case in light of the judging person's experience with similar cases. And it's quite interesting from my point of view that in a posthumously published paper that was a precursor to his chapter 7, Hart suggests that discretion is an actor exercise of discerning, and that it would be a mistake to identify the notion of discretion with the notion of choice. Okay. I think that's a very interesting difference between what he says there and what he says in chapter 7. With this new conception of discretion, we can say that Cardoso exercised discretion in deciding McPherson in changing the applicable rule, but this does not mean that he relied on extra legal considerations to go beyond the pre-existing law. Instead, we can say that Cardoso adjusted the explicit legal rule so that he could be more faithful to the underlying or implicit legal facts. Thank you very much.